Hello, everybody. Paul Rabelais here. Another edition, number 7, I believe, of the 20 YouTube unique, different, estate planning-oriented YouTube live presentations in 20 days here in the year 2020. All right. Hope you enjoy the joke of the day. This one has a little bit of a Louisiana, or maybe a lot of a Louisiana flavor to it. It's about a Louisiana form of ownership. I'm sporting my LSU shirt here. Got to do it whenever I can. Felt like today was an appropriate day to do that. Want to start like I usually do with maybe answering a comment or question that someone posed on my YouTube channel, Rabelais Estate Planning LLC. Then we'll jump right into the Louisiana Usufruct. What is it? What are the pros and cons? Why do people like it? Why do people don't like it? Give you some examples, go from there. All right, so looks like 38 minutes ago, Cheryl May asked a question on my YouTube channel. Child A lives in, and let's see, this is in response to the yesterday's Make a Children's Inheritance Divorce Proof presentation. Cheryl asks, Child A lives in community property state. Child B lives in marital property state. Can I leave estate 50-50 in a trust? Well, of course you can. So wherever you live, Cheryl, you can create a trust and leave what you have to your kids 50-50. Yeah, you may want to take a look at yesterday's recording, which apparently you did, to see if you want to add any extra layers of protection just to make sure that what your children inherit stays with your children, perhaps even down the road if there's anything left when they pass away going down to your grandchildren. So, but you're certainly permissible. It doesn't really matter where your children live. You certainly can leave the trust or leave the estate 50-50 to each child, regardless of where they live. Okay, let's see. Not much other in the way of housekeeping. If you got a joke, let's bring it on. If you got some questions, bring them on in the live chat. I say it every day. I love the live chat. It's one of the reasons why I'm doing this live, to give you an opportunity to ask questions. There hasn't been a question asked in the last 6 YouTube live presentation that I haven't at least attempted to answer. So that's why I like the live chat. Also, YouTube records it, puts it on the YouTube website, and then people can search it and find it, and so they can get the benefit of the presentation, even though they're not watching it live. Okay, so the Louisiana Usufruct, and just for what it's worth, Louisiana, derives many of its laws from the kind of French civil law. Many other states, it's the English common law. I don't want to get too much into that, deep history stuff. I like to stay practical. Bring it on, Ron. You got me now. You got me so flustered, Ron, that I gotta see the answer. What is black and white and red all over? Bring it on. All right. I guess you're letting people think. The newspaper. Okay, the whole red word there got me. Most people don't even understand how to say the word usufruct, and it's spelled Usufruct. And so some people, especially down here in Cajun country, usuflux, usuflax. Sometimes they accidentally get a little F word in there, and it just we laugh every time we hear someone mispronounce the word usufruct. But that's how it's pronounced. Sometimes people want to put an S on the end, usufructs, but it doesn't have an S on the end. It's usufruct. And it is, here in Louisiana, is a very, very, very common form of ownership for reasons I'll explain here in just a second. In fact, it's common because in our intestate laws, intestate means you died without a will. And there are statistics all over the place. 50%, 60% of Americans die without a will. But in Louisiana, when a Louisiana resident or domiciliary when a married person dies without a will, then our state law governs who gets their stuff, just like any other state has those laws. And Louisiana's unique intestate laws provide that if a married person dies and they owned without a will, and they owned community property, they bought a house while they were married, they accumulated some money in the bank while they were married, all that's community property, all those things that they acquired during their marriage. As to the deceased spouse's half of the community property, the deceased spouse's surviving spouse inherits this usufruct of the deceased spouse's half of the community property. But because a usufruct is just this right of limited duration, whenever someone inherits the usufruct, others are inheriting what's called naked ownership. And under our intestate rules, when a married person dies, their spouse inherits the usufruct of their half of the community property, and the deceased person's children inherit what's called the naked ownership. Another word we have fun with because it starts with the word naked. And so you've got usufruct, which some people mispronounce and throw the F word in there somehow. You've got naked ownership. As we sit in meetings and people start hearing these terms and pronouncing these terms, they're like, what is going on with these crazy terms that we have? But it is what it is. The children inherit naked ownership, meaning when that usufruct terminates, the children go from being a naked owner to a full owner, I'll call it. So I'm going to give you some really simple, easy examples to understand all of this here in a moment. But it's common because the intestate laws provided for a usufruct to the surviving spouse. And since so many people in Louisiana were familiar with it because the intestate laws provided for it, many lawyers started writing it in the wills. I leave my spouse usufruct of my estate, and I name my children as the naked owners. Not too much different than the life estate remainderman area that we have in other states outside of Louisiana. So let me just give you the boring technical kind of legal definition stuff on certain issues, and then I'll give you really the practical break it down, now I understand it explanation. So, if you look at the definition of what is a usufruct, it's a real right of limited duration on the property of another. So it's a right that you have for a certain period of time. We'll get into that period of time in a minute. And then the features of this usufruct right vary with the nature of the things subject to it as either consumables or non-consumables. So we'll dig in a little bit about what does it mean to have a usufruct of a consumable and what does it mean to have a usufruct of a non-consumable. What's all that about? So we'll jump into that. And now let's jump into it. Let me give an example. So let's say dad dies, and let's say he died without a will. And so there's dad and mom. Dad dies first. Dad has 2 children. And because he died without a will, dad's half of the community property consists of, let's call it $1 million of cash. Might be in one or more bank accounts, might be in CDs, savings, checkings, it doesn't matter. $1 million. Like to use a big number. But the same rule would apply whether it was $10,000 of cash or $1 million or more or less. So what dad is leaving the usufruct of is his $1 million of cash. They had $2 million together as community property, so his half is $1 million. Dad's also owned his half of the stock that they had. His half was 1,000 shares of stock, valued at $1 million on the date that dad died. I guess that's $100 or $1,000 a share, whatever it is. But it's 1,000 shares, $1,000 a share, worth $1 million. Dad also is leaving her the usufruct of a house valued at the time dad died $350,000 and a vehicle as well. Okay. Let's clarify my example. Instead of dad dying without a will, let's say he had a will, but he left the usufruct of his entire estate to mom. And so he left his half of the community property. He left her the usufruct or was given to him, or he brought it into the marriage. That also, she got the usufruct of that. And let's say their house is his separate property, although it usually isn't. But maybe he inherited it and they lived in it. Now we got to touch on this consumable versus non-consumable thing. Let me hit the key provision here. So consumable things are those that cannot be used without being expended or consumed or without their substance being changed. By far, the most typical consumable item is money in the bank. So that's a consumable item, and mom's rights over the consumable items are different than what they are over the non-consumable items. So dad left mom usufruct of $1 million of cash. That's a consumable. Let me define a non-consumable, because these other assets that dad had are non-consumable things. Non-consumable things are those that may be enjoyed without alteration of their substance, although their substance may be diminished or deteriorated naturally by time or by the use of which they are applied, such as lands, houses, shares of stock, animals, furniture, and vehicles. So of these other things that dad owned, he owned $1 million of cash. That's a consumable. And he owned shares of stock, he owned a house, and he owned a vehicle. Those are all non-consumable items. Now let's talk about what dad's rights are, or mom's rights are as the usufructuary. I'm getting into some big words. Dad died, he left mom the usufruct, so now mom is what's called the usufructuary. I laughed one time when on the National Scripts Spelling Bee that they have every year on ESPN, although they didn't have it this year because of the virus. I was watching it one time, and they asked one of those little 12 or 13-year-olds, one of the words that they were asked to spell was usufructuary, and I just got a kick out of that. And lo and behold, they got it right. Okay, so let's talk about what mom's rights and obligations are as the usufructuary of cash, stock, a house, and a vehicle. All right, so the cash is a consumable. So what are mom's rights? Mom becomes the owner of that $1 million of cash. In fact, it says here in the statute, if the things subject to the usufruct are consumables, the usufructuary becomes owner of them. He may consume, alienate, or encumber them as he sees fit. And then here comes the obligation that the usufructuary has. At the termination of the usufruct, he is bound either to pay the naked owner the value that the things have at the commencement of the usufruct, blah, blah, blah. All right, dad dies. He leaves $1 million in bank accounts. He leaves the usufruct of it to mom. Mom becomes the owner of that $1 million. She can do what she wants to with it. However, when the usufruct ends, and we haven't talked about the termination of the usufruct yet, but we'll talk about it next. When the usufruct terminates, she owes the naked owners that $1 million. All right. So dad had 2 kids. They're the naked owners. Maybe they are the kids of dad and mom, or maybe they are just dad's kids and mom has no kids, or mom has kids of her own. Dad dies, leaves mom the usufruct of $1 million. It goes into her name. She does what she wants to it. But when her usufruct terminates, which is likely going to be either when she dies, or it's going to be at the earlier to occur of her death or remarriage, depending upon what dad's will said. If dad died without a will and she got the usufruct of assets, it would terminate upon the earlier to occur of her death or remarriage. But oftentimes wills are written leaving a surviving spouse the usufruct that lasts for the lifetime of the surviving spouse. So she can do whatever she wants to with $1 million. She can go invest it. She can spend it. She can buy a house with it. However, when her usufruct terminates, and let's say it was a usufruct that terminated at the earlier to occur of mom's death or remarriage. So if mom remarries at that moment of remarriage, that's when she owes dad's 2 kids $1 million. Or if her usufruct lasts for her lifetime, then when she dies, her estate owes dad's 2 children $1 million. And so dad's 2 children get the first $1 million off the top before mom's heirs get anything. And then the typical question that we always get is, what if mom doesn't have it when her usufruct terminates? Well, if she doesn't have it, she doesn't have it. But to the extent there's $1 million there in mom's estate, whenever that usufruct terminates, dad's heirs, dad's naked owners are entitled to that first. Okay, so that's the deal with the usufruct of consumable things like cash. And then we got two more rules to go over. One is the usufruct of a non-consumable, and then the mouthful, the usufruct of a non-consumable that is subsequently converted to a consumable. Okay, so Dad had 1,000 shares of stock. He left Mom the usufruct, and when Dad died, that stock was worth $1 million. And let's make it easy. Mom never sells the stock. Her usufruct terminates, and she still has that 1,000 shares of stock. Now it's worth $2 million. Well, because that is a non-consumable, then when Mom dies, the children get the stock. They get the 1,000 shares of stock, regardless of whether it has appreciated or depreciated in value. The kids get the stock. So same thing with the house, same thing with the vehicle. If Dad died, leaving Mom a house that was worth $350,000 when Dad died, but let's say it went down in value to $250,000 from the time that Dad died till the time that Mom died, then when Mom's usufruct terminates, kids get the house. So you're starting to see that, kind of different rule here for non-consumables. But now let's go back to that 1,000 shares of stock that was worth $1 million when Dad died, and it appreciates to $1.5 million while Mom is alive and while Mom has the usufruct of it. And then Mom sells that stock for $1.5 million. So now what Mom did is she just converted a non-consumable item to a consumable item, and upon the time that she converted it from a non-consumable to a consumable, she sold it for what had been a $1 million worth of stock. She sold it for $1.5 million. At that point that she converted that those non-consumables to a consumable, now that establishes what she or her estate owes his naked owners at the termination of the usufruct. The kids don't get it when she sells it, but whenever her usufruct terminates, perhaps when she dies, or perhaps when she dies or remarries, whichever comes first, then that's when the kids are going to be due $1.5 million, the amount of the proceeds of the sale when it was converted from a non-consumable to a consumable. Okay, and you could apply the same rule to the house. You could apply the same rule to the vehicle, although the vehicle diminishes in value, and Mom would probably sell that for less, and then that would be less that the naked owners would be entitled to. So you've got the consumable and the non-consumable there, but essentially the usufructuary, I kind of skipped over this part, is entitled to all of the fruits that the asset produced, particularly the non-consumable. So if while Mom had owned her usufruct of the stock, it produced dividends, Mom gets those dividends. She becomes the owner of the dividends with no responsibility to account to the naked owners for the fruits of the assets over which she has a usufruct. Mom can vote the shares, again, if she has the usufruct of stock. And then we've got a bunch of rules regarding what are people's rights upon improvements and alterations. Let me just maybe go over a simple one here because we get asked about it a lot. About, let's say Mom gets the usufruct of a house and she wants to make some improvements or alterations. The usufructuary may make improvements and alterations on the property subject to the usufruct at his cost and with the written consent of the naked owner. If the naked owner fails or refuses to give his consent, the usufructuary may, after notice to the naked owner and with the approval of the court, make at his cost those improvements and alterations that a prudent administrator would make. So there's an example, and there's several on repairs, extraordinary repairs, ordinary maintenance and repairs. I'm not going to get into that too much because that gets too much into the weeds. This is really an introduction kind of to Usufruct YouTube live presentation. All right, so let me now, with all of that, let me give you some practical examples. Let's say Dad dies. He either intestate or with his will, he left Mom the usufruct of his estate, named his kids as the naked owners. If it was an intestate usufruct and Mom remarried, then again, at that point of her remarriage, she has to settle up with his kids. And I know that some surviving spouses who have the usufruct that would terminate upon their remarriage are reluctant to remarry because they don't want to give up those funds that they would have had, continued to have had usufruct over. So they often don't remarry, and they, live with their significant other in order to keep their usufruct plugging along. And then also, if the usufructuary is not the parent of the naked owners. So let's say dad has 2 kids of his own. Dad leaves the usufruct of his estate to wife, who is not the mother of dad's children. Either he leaves her the usufruct or it's an intestate usufruct. Because wife is not the parent of the naked owner, dad's children can force surviving wife to post a bond or post security. So they have to go to an insurance company and purchase a bond and pay for it every year in order to protect dad's children from his wife's squandering of the assets over which she has the usufruct. Now, that bonding requirement can be waived in dad's will. So dad's will could say, I leave my wife the usufruct of my estate, and I relieve her of posting any security as the usufructuary or something to that effect. And now his wife would inherit the usufruct and not have to post a bond or security in order to protect the children's future inheritance. All right, a couple of other issues. When someone does have a will, they often provide that the usufruct lasts for the lifetime. If they do that, this applies to the super wealthy. It qualifies for something called the estate tax marital deduction, or Q-tip treatment, which means if the first spouse to die had a really large estate in excess of $11.58 million, no estate tax would have to be paid. They could essentially defer the tax and move assets over the exemption amount into the estate of the surviving spouse, perhaps to be taxed at a later date. But anyway, if estate taxes are a concern and you're leaving usufruct to a surviving spouse, it may be very helpful to say that your surviving spouse's usufruct lasts for their lifetime, because that's the only usufruct that qualifies for this special estate tax marital deduction treatment. And then in most wills, when someone leaves their spouse the usufruct, they typically add the extra language in there that allows the surviving spouse to what's called dispose of non-consumables. If husband leaves his wife a usufruct of the house, and in addition, he provides that she has the authority to dispose of non-consumables, then she can sell the house by herself without having to get the signature or consent of the naked owners. She still has those accounting obligations at the termination of the usufruct. It's just a person who writes a will and leaves usufruct can give the usufructuary the authority to dispose or sell non-consumables, because if you don't provide that, then that surviving spouse has to get the permission of the naked owners in order to sell a non-consumable item. Okay, so here's another issue that has come up a lot, and it kind of ticks me off whenever I see it. I'm like, I wish you would have looked into this a little more. So sometimes, let's say dad dies, mom inherits the usufruct, children are the naked owners, and at the time dad's probate or succession is being complete, somebody brings up, maybe the lawyer, maybe mom, brings up, all this usufruct naked ownership stuff. It's complicated. So somebody suggests, well, maybe just to make it cleaner, let's just get the children to donate their naked ownership rights that they're inheriting from their father. Let's just get her to donate them back to mom, so mom then can be the full owner, and we won't have this usufruct naked ownership stuff going forward. That seems to be complicated. So they prepare paperwork that way. They sign all that paperwork. It gets done where now mom's the owner of everything. And then mom perhaps remarries, or mom's relationship with the children starts to deteriorate. And when mom dies, mom has ownership of that entire estate. She can leave the estate to whoever she wants to. There's no protection in place for the children who had the naked ownership rights, but they gave up those rights. So boy, have I been in a number of meetings where the children, when mom winds up leaving it to somebody else, the children come in and said, I want to go pursue my naked ownership rights because when dad died, I inherited the naked ownership. But I'm like, but you signed over those rights to your mother, so you don't have naked ownership. And then the child says, well, I didn't know what I was signing. They just asked me to sign some stuff, and I did. And that's where the problem lies. So if you're a child and you have your parent has died and you have kind of by law inherited the naked ownership, you got to be careful of what you sign and what you do for that surviving spouse or maybe even your surviving parent, because you may not know what rights you've given up until that surviving wife, husband, parent dies, and then you're in trouble. So be aware of that. Also note that this usufruct isn't just for a surviving spouse. We've had a lot of situations where parents passed away. They left the usufruct of their home maybe to one of the children until that home gets sold or the child moves out or till the child dies. And then that home will be owned by all of the children. Sometimes parents want to make sure a child has the right to live in the home, but a child, that same child doesn't get an extra portion by inheriting ownership of the home. So we see that sometimes. And then one of the final things I want to do is I want to compare the usufruct to leaving things in trust. The biggest difference is, how dad left mom the usufruct of $1 million, and let's say she had to spend over her remaining years, she had to spend $600,000 of that just to live off of. Maybe she needed assisted living facility or nursing home care or some skilled care. Maybe she needed care in her home. But after dad died, she inherited the usufruct of $1 million, but she spent $600,000 of it. So when she died, there was $400,000 remaining. Well, by inheriting the usufruct of $1 million, when her usufruct terminates, she or her estate still owes the naked owners the $1 million, even though she spent $600,000 of it. Some couples, as they're putting things in order, they don't like that. They would prefer that the husband, I leave my $1 million in a trust for the benefit of my wife. And if my wife needs to use that $1 million in trust for my wife's health, education, maintenance, or support, she can use it. And then when my wife dies, whatever remains in that trust would then go to dad's children or dad's heirs. That way, when the surviving wife died, having spent $600,000 of the $1 million, only $400,000 remaining, then dad's heirs would be entitled to just whatever's left or that $400,000 in our example. And so that's a significant difference between a usufruct and a kind of typical trust arrangement, is what is the accountability of that survivor. Questions, put them in, because we're kind of winding down, and as soon as I stop, I turn this sucker off. And so if you got some questions, throw them in the live chat. Today was a Louisiana-only version. We're going to get back into just some of the regular stuff that applies to you wherever you live in whatever state in our country. Maybe some of our stuff will apply to you even if you're out of the country. But tomorrow is all about how to complete a probate. Oh man, that is a boy. If I could educate heirs on what to expect and what to do to make the probate easier, then a lot of families would stick, quite frankly, relationships would stay intact. Now, I'm not that good, and I know some relationships among siblings and family members are just not repairable. But if families go into a probate with the right expectation, then that can really make things easier and not so stressful as so many of them get. So that's going to be all about tomorrow's. If you know anybody who is maybe their children will have to go through a probate, their spouse and children will have to go through a probate one day, or you may have to go through a probate one day and you want to be really educated about what that's like. Stay in tune tomorrow, 10 a.m. Central Time, how to complete a probate. Looking forward to it. And I think we're going to wrap it up here for today. Make sure you hit the like button. We've got 4, it's a gray thumbs up button. We want to make it blue. Blue's a better color than gray. Blue tells YouTube, show more people Paul's videos. Hit the subscribe button and the notification bell as we get those subscriptions up, and helps the YouTube algorithm stuff. All right, we'll see you tomorrow. Y'all have a great rest of the day. Bye-bye now.